So let's talk first about what materials are available to you, to all of us, as practicing journalists, as attorneys, whatever, members of the public, about the judicial process, about the court system. And both Ron and John have provided materials that, in the handouts, that will be helpful to you. And let me just turn it first to Ron so he can talk about that, and then John can chip in as well.
Well, if you're not familiar with the Kansas Court's website, I would encourage you to become familiar. If you'd pull out in your handout or your packet a handout, it's a screenshot of our homepage, I think I can point to quite a bit of information you may not have realized is on there, or know what you can find out by just tickling the computer from your desktop. And I've numbered I think what I consider the highlights of the page for a journalist, from a journalist perspective, on the handout. And the first I would draw your attention to, every attorney who is registered in Kansas has an online lookup, phone number, correct spelling of name, office address, number one there. So anytime that you have a question about a case, or thought you heard some lawyer's name, you need to know how to get a hold of, or how to spell even, I draw your attention to that link. Recent published decisions, you can click there and find all the decisions that have been published, and what we call published are ones that are ultimately put in bound volumes, books. But we have everything online dating back to when our website was set up in about 1995. You can also search those opinions, keyword, on our main page. On this page, you look at the upper right, number 10 on the upper right corner, you'll see you can search the whole website, or you can just search for opinions. So anytime you want to know about a opinion, you can look at recent and published opinions or do a keyword search there. There's also another search block on the opinion page. A lot of people don't know, but you can find out the exact status of any appeal in Kansas at number 3 there, the appellate case inquiry system. And if you follow that link, ultimately you'll get to plug in a name search box, and that will take you to a total history of all the filings that have occurred in every appeal. And if it's a story that you want to see the not only what happened or when happened, but you want to see the document that's filed, all you have to do is give me a call. And that's one reason I put my business card in these folders. Give me a call. I have access to the image documents, and I'm more than happy to get to those documents internally and send you an email that will have a PDF of virtually every document that's filed in any appeal. So keep that resource in mind as you try to cover the appeal process of a case from your area you're interested in. Search district court records. That's a troublesome spot. We were talking about e-filing this morning. We do have a search mechanism. It's relatively inexpensive, but the problem is you cannot go statewide. You have to be able to identify a county. So if it's Pawnee County, you can go to Pawnee County and look at their record, but you can't look for the same name statewide. There's also a fee involved, and it's not that bad. I think it's $1 to look up and then download any additional documents is I think $1 a download. Supreme Court of Appeals dockets, excuse me, of course, are online. You can go to them currently, or you can see when previous dockets were. Number 7, view oral arguments. We've already talked about the video stream, and by clicking there, you can go to a link and actually watch Supreme Court arguments. 8 is a current and archived filing of all the news releases I've done, or majority. 9 is another link to the case inquiry system that is the same as number 3 that earlier. 10 is a keyword search of the whole site or opinions. 11, if you do the drop-down tab there, you can go to any county in the state and get contact information, names of the contacts of the judges, court administrator, clerks of the court, but also a link to caseload stats, or if the local district court has its own website, and I would guess about 15 maybe do out of 31 judicial districts, maybe about half do. You can go there, and I'll let John talk about what might be on the district court website. Again, 12, the archive or live video stream. 13, I try to update this as frequently as I can, or I have things to update. So if you're ever in the newsroom looking for a story, you might just take a look here and see if there could be a feature. You know, when I was a journalist for those 17 years, I covered the Shawnee County courts, and I maintain that there is absolutely no excuse for a reporter not being able to come back from a courthouse without a good story, because every file cabinet and every file drawer in that file cabinet has a feature story just waiting to be written, whether it's on bail bonds, whether it's on on the how care and treatment cases even are for juveniles are handled, assuming you're not going to be able to identify the child. But they're just any number of features that are just waiting to be written by a reporter. One other message I would have that Eric mentioned, Westlander mentioned in the last panel: go to the courthouse. If you're covering it, spend as much time as you can and as little time as needed in the newsroom. I spent most of my time in the courthouse as a or as a journalist, and I know that anytime I wanted to come up with a feature, I could just walk by and any court and think of something that court records would support. So that's kind of a quick overview of how, if I were you, I would approach the appellate court cases.
Thank you, Ron. Let me turn it to John, but first let me ask him a couple of questions sort of to set this up. Remember, I said we're going to talk about covering trials. Let's say that there's a potentially sensational case that's been filed in one of the counties for which John is responsible. John, tell us what you normally have available for journalists and other people who are curious about cases. And then if there is a potentially sensational case, whether there are any sort of special materials that you might make available to the press.
Thank you. First, I just want to say I'm honored to be here. I think I've been in the judicial branch for 30 years, and I've been in this room many times, but every time I'm in here, it seems special. So I just want to say I'm honored to be here. Usually I'm from a rural county that doesn't have a lot of high-profile cases, but when we do, I figure that's probably why I was invited to be here to talk about the horror stories, maybe of district courts that really haven't had much experience and aren't very polished when some big giant case comes along. We have had a few, and but 99% of the cases probably we have don't have a lot of media coverage. There aren't media there, but we do try to make sure that information such as the court schedule, the court docket, court contact information, and then the court case information itself is as easy to obtain as possible. Certainly, like Ron said, we, at least in the 4th District, have a fairly robust, I guess is the word, website that tries to give all the information, all the contact information on court clerks, court administrators, the judges, We also, I don't think a lot of them do, but more judicial districts in the state are heading that way, have the court schedule on there, on the docket. You can go to the court doc, or on the webpage, you can go to our webpage and obtain court schedules for all 4 counties. We try to update it daily on do it, so sometimes it's not every day, but it's pretty accurate. Obviously, if there's a case that occurred last night, it's a big giant case that's probably not going to be on the webpage right away. I think there was discussion about Rule 101, I believe, and that's obviously what we follow. That's what the judges in my district want to make sure that they follow that rule, and especially about appointing a media coordinator. I think there's 17 court administrators in the state, or 18, I'm not sure. Not every district has one, but I'm pretty sure most of the local courts, the judges have appointed them as the media coordinator. Probably the best 2 words I can give you in terms of covering successfully local courts is call Ron. That's probably the best 2 words. You write that down, you got it covered. He can contact and knows every local court, every judge. If you need to get information that's not available on the web pages, you call Ron. But in terms of, if you come to our courthouses, we have and you're just covering court cases on a daily basis, or you're there, we post all the court schedules at the entrance on paper, so you can walk in and look and see what cases are there. But I would say if you have a case and an inquiry about a case, at least in my district, if you call and you get the clerks, they're going to refer you to me. And probably that's the way it's going to be in most districts that have court administrators. They're the appointed media coordinator, and the best person to contact is them. We can give court schedule information over the phone. I believe pretty specific, just, okay, there's going to be a hearing tomorrow, or this is when it is. We'd be glad to give you that. If there's more interpretation of something that's a little farther than that, we probably won't. When the media sends requests for me for either court we also scan all the court documents, and they're available digitally. So, we would prefer if you call and it's a public court document that you want a copy of, we will. It's probably easier to email us. Their email addresses are on there. Email us, and we'll attach it as a PDF and send it right to you.
Is this on? John, let me ask you a question about getting court documents. You said that the court documents are available. Is there a way that someone, say, remote from Ottawa or remote from the court about which they have an inquiry can get access to the docket, and so perhaps identify the specific document they might be looking for?
Yes, yeah. You can, just like Ron said, now if you do the pay fee court record search, you can get into any case. If you know the county, you know the specific case, go in there and it'll show the whole register of actions, they call it, all the actions in the court case. It does not have documents in there, but it does kind of say, it would say, if the clerk said if a document was received as a petition or a summons or something that's open to the public, if it says that there, you then could send an email and request that document. You could also come to the courthouse, but then they probably charge you 25 cents a page per copy. It's probably better to send an email request. I would entertain those.
Well, I can tell you from the point of view of a practicing lawyer that getting a hold of somebody like John may not be the easiest thing in the world. He's very busy, obviously, but I have learned to call the clerk, call the district court clerk's office. They know, John may say he knows everything. The clerks really know everything, and they're almost universally helpful. But to get back to the topic at hand, a sensational case has been filed. John said that Ron gets involved in helping set things up. If the court believes that the media is going to pay particular attention to the case, what efforts, what do you do, Ron, to help the local courts get ready for the media onslaught?
Well, I do participate in immediate coordination of a high-profile case around the state. I've been down to Great Bend, been down to Kingman this year, helping long distance in Norton. But Mr. Steelman had I don't know what days it were, but whenever I had a day off, that's when someone calls, and I remember, what was that about? I was holiday, or I don't know, I was home, but John called and said, oh, got this State versus Taylor case, what can we do here? And did you suggest it, or did I, about posting the documents? I guess maybe I did.
You did, yes.
Yeah. I told him what we had done in Great Bend with great success on a murder case was to post all the major filings in the case online. It was ad hoc, what I call an ad hoc website. And I had done that several times before Great Bend, but Great Bend most recently. And it did two things. One, it made access to those documents easy for the media, but it also, from John Steelman and others' perspective, eliminated all the calls by the media to the clerk's office who already are trying to catch up from furlough days about looking up documents and trying to, number one, determine whether that's something they can make available, because clerks may know about it, they're not sure what they can say about it, Mark, I would say. So by eliminating, the necessity to go to the clerk's office for public documents and posting them all in one place, plus we were able to also, of course, indicate what the next proceedings date were, really took a lot of pressure off the clerk's office. They, to this day, every place I've been, keep saying what a wonderful job it is. So I am encouraging judges across the state to think about that. If I could, Mark, I want one more anecdote story along those lines. In Norton County, and someone already said a 6.5-hour drive from here, he had a murder case. We did the ad hoc website. That was great. Worked just as I described. But then the judge had a grain company fail, and the grain company had granaries in different counties. And it wasn't the media that he wanted the ad hoc website set up, or he wanted it set up so that all those grain depositors, instead of calling the clerk's office, could see exactly what was going on in this foreclosure proceeding. And there were monthly, and the key filings were monthly, reports of the status of the grain. I don't know much about silos, but in any event, all the landowners or all the owners could just go to the website and so there's really, I think, a great need to put as much of this stuff online and open as you can. John, you may want to go ahead and follow up a little bit on Caleb too.
Yeah, that must be the reason I'm here. That's probably the biggest high-profile case that we've had in our district. And I remember that Thanksgiving weekend.
Was that it?
It was Thanksgiving, and heard with the family hearing the news about the alleged offense, and wondering, hoping it was in Shawnee County, and realizing it was in Osage County, and knowing exactly what was going to be taking place on Monday when we all got back to work. But I think that the specific webpage just for that case is still on our webpage, and if you ever want to look at it, go to the Fourth Judicial District webpage, and under media inquiries, it lists, and it has, I think it still has all the actions, all the documents that were filed, that were public, information about the judge, and then we also kept up with the every hearing, so you could go in there and look without trying to track me down or the clerk or some other court personnel. We also thought it's, when it comes to fairness, since we're the courts, we always thought we needed to be fair to the same thing with trying to decide who's going to be the pool photographer and all that, to try to be fair to the media and not special treatment to whoever, So it certainly was a big time saver for the courts, and I hope that it was something that anybody that needed the media needed to get in and gain access for your work, is easily accessible.
John, thanks. We're going to move into talking about the trial period itself, or the period in which the trial is ongoing. But let me make one point before we get to that, and that is, I think it's a great idea, particularly for the journalists, to visit the courthouse, visit the courtroom before the trial begins. And it doesn't matter whether you've seen one. Not telling you the truth, because they're all a little bit different. They're all configured differently. Some are very small, some are large, some will accommodate 10 spectators, some can accommodate 100 or more. So I think it's a great idea, a day before, a week before, just whenever you have some time, to go to the courthouse, introduce yourself to the clerk, unless you've already done that, and then see if somebody will walk you through the courtroom. If the courtroom's open, you can go there by yourself. But I think it's absolutely crucial that you get the lay of the land before the events start to happen. Figure out where you want to sit, figure out where the best sidelines are, figure out the best places to be able to hear things. So just a little bit of reconnaissance, I think, will stand you in good stead. But let's talk about the trial itself. One of the big issues that journalists have in covering trials is figuring out when to go. Because we know that there are a lot of things happening in trials that really aren't newsworthy. A lot of things that happen that maybe your readers or your editor really is not or aren't that interested in. How do you find out? Can the court make information available to you that will give you a good idea of when it's really important to be at the trial? John?
Especially for high-profile cases where there's going to be media and there's going to be, for high-profile cases, and usually the attorneys are already on top of this, but they would suggest that there's a witness list, there's a list of all the witnesses that are going to be taken, are scheduled to be there, be on the stand that day, and that's available usually on the docket calls of, sentencing and that sort of thing, where there's 100, 105, 30 cases in an afternoon or morning. That's probably not the case, but on the cases like that have a high interest, I know Ron's done that before. There's been a list of the witness list to know exactly what's coming up. A lot of times that doesn't all work out just right, but I think that's been helpful.
I'll pass this to Ron in a second, but I can tell you from the lawyer's point of view that the witness list, more to the point, the witness schedule is very important. When a judge asks us, what witness are you going to put on in the morning? And you say, well, judge, it's going to be so-and-so. If so-and-so doesn't show up, or you decide not to put him on, you need a pretty good excuse. The judge otherwise is going to be unhappy with you. So if you can talk to somebody like John or someone in his office, and they tell you that so-and-so is going to be testifying tomorrow, and you think that's going to be an important witness, you can pretty much rely on that person being on the stand in the morning. Ron, any thoughts to add here?
Well, I'm looking back at Jackie Spradley, the chief assistant district attorney in Shawnee County, getting to know your prosecutor and defense attorney is step two. I mean, I encourage the chief judges around the state to invite new media in, take them on a chef's tour of the building, show them how and where and when you can get various and sundry documents. But I think the district attorney's office would be the next step if I were a reporter, get to know those the DA or county attorney and the assistants, and that's where frequently if you don't have a PIO or media coordinator specifically assigned to a case, that's probably your best source would be the attorneys.
Yeah, we have a question.
Just a quick question, point of order along those lines. Yeah, thank you. A lot of times in high-profile cases that we wind up covering, there's gag orders in place where we're specifically not allowed to speak to any of the attorneys involved. How these schedules of, because obviously we frequently get lists of witnesses or these prospective witnesses, and a lot of times those are a lot lengthier than the number of witnesses that are actually called. Regarding the actual scheduling of witnesses, how big of an inconvenience is it to call the clerk on a daily basis to find out like who's going to be testifying the next day? How many days in advance do lawyers generally know regarding the scheduling of witnesses coming up?
Maybe an hour or two ahead.
Yeah, that's kind of where I was wondering with that. Because like what she said is great advice, but I'm just kind of clicking through a lot of the trials I've covered out here, and just about every one of them that's been newsworthy, we haven't been allowed to talk to the prosecutors throughout it. So that's where I was kind of wondering as far as specific scheduling.
Not even for witness lists?
For witness lists, yeah, but a lot of times, like for example, the the Longoria case in Great Bend that you've been discussing, I think the witness list for that was something like 120, and we might have seen 40 on the stand.
I agree with you.
Right. Trust me, you were awesome. I didn't mean that to sound critical.
I'm just saying things change a lot throughout the course of the trial.
Thanks, Justin. In fact, I was going to turn this over to John to ask about, what's the availability of witnesses? What's the availability of participants in the trial while it's ongoing for interviews by working journalists? And is there, did the court somehow intervene in that process?
The short answer is there isn't much availability during the trial, but I'll let Ron make sure he has a proper answer.
And what kind of, let's say, order is it, or what sort of process does the court follow in limiting that access?
Well, they, I believe that after the witness is testified, the judge will ask if this witness could be excused, and I still don't think that this isn't something that's my expertise, but that whether or not they're allowed to be interviewed and that sort of thing. We certainly can talk about jurors at the very end of the trial. That's one thing that always comes up. But during the trial, I might let Ron handle that.
Okay, in your folder, I've included a standard gag order, and the quote gag and quote order really just parrots Rule 3.6 of the attorney discipline code that sets forth what lawyers may say and examples of things they may not comment on during the trial. Most judges in high-profile cases anymore are entering these as a matter of course. I've always objected to the idea, but they're based on California maybe, where the routine is the lawyer gets out of the courtroom and then holds court public opinion on the courthouse steps. And to avoid that, I don't know if this trend is going on. Usually, though, in the cases I'm involved in, the judge will have another order that says direct your questions to Ron Keefover, or in this case, maybe to John Steelman. And I think that's the best of both worlds. What the idea that we've been operating under is, let's have all the questions come to one person who then takes them to the judge, rather than have 10 or 15 media outlets trying to get information, while the judge is also trying to preside over a proceeding. So, that concept works. I've never envisioned myself as a gate, as a roadblock to coverage, but more as, I hope I can get this for you kind of attitude. And so, during the trial, a judge who has entered this, attorneys actually jump at the chance to be able to say, "Oh no, look at that, read that. I can't comment on anything." Well, a lot of times, this specifically exempts, among other things, procedural. When's the next hearing and that sort of thing. I think that's all fair questions, or asking the attorney for a witness list. My practice is, because lawyers don't know that far, I mean, they have an idea, but not locked into the schedule of witnesses. I try to, when I'm coordinating the trial for the media, I try to get at least a daily, if not a morning and afternoon, rundown.
And that's the way it was with State versus Kaler, and it worked pretty well. It didn't always go exactly right with witnesses, but they had a daily of pretty much, here's who they, the 2 or 3 they think are going to. And also I would just add that, especially with the high profile case, we would, from the court point of view, we want to try to deal with these questions and strategically plan prior to the case, the start of the trial. And talk about, try to get all these answers from the judge. As the liaison from the media to the judges, I'd probably, any questions, we have meetings up front and say, where are you going to be stationed? How's it, where's the camera going to be? Where's the media going to be located? Where are you going to be able to interview anybody at any time? How are we going to deal with jurors, with witnesses, all those things? We tried to make sure that that was all dealt with, and so everybody had an idea prior to the trial starting.
Yeah, and let me point out that the gag order that's in the materials you have specifically exempts from material covered by the order things such as scheduling issues, the identity of persons involved in the case, results of hearings or trials. So there's a lot of material that would be useful, if for nothing else, as background to you in helping flesh out the stories that you may be writing, that the attorneys, that the participants in the case can tell you about. And sometimes you can get useful information from the court personnel. You want to find out when is the case going to be, it's been adjourned for a while, when's the case going to be called again? Well, the bailiff, the courtroom deputy might be able to tell you it's going to be tomorrow at 2 o'clock, something like that. So bottom line is, don't be afraid to ask. They may say, I don't know, or I can't tell you, but you don't know that answer until you actually ask the question. Let's talk for a minute about an event that occurs, I guess, technically after the trial ends, but still when things are hot, and that's talking to jurors after the case is over. And Ron, let me turn this to you, and then get some comments from John about that.
All right, can we back up to exhibits?
You have the microphone.
All right, one of the thorniest, I want to get this off my chest, one of the thorniest issues that I'm being confronted with, and have been, and I'm not sure what the resolution is, and that is the availability of exhibits submitted to trial. Some judges, have no problem with, yes, here is a copy of the exhibits. Others take the position that, once you've seen them in the courtroom, that's it. And then we had a situation, and this brings me to my juror question, but we had a major jury trial in Lawrence, where 48 Hours was out actually operating cameras, and their request to the judge, trial judge, was, can we take pictures of all the exhibits? So some of the exhibits were gruesome photographs and handwritten whatever that couldn't have been very prejudicial. But 48 Hours said, oh no, we won't run. First, we won't run any of the gruesome stuff, but second, we won't show anything until after the jury verdict. And so on that basis, the judge said, okay, at noon hour, whatever exhibits have been admitted, a court reporter will bring them in, you can take the video and still shots and leave. Well, the Lawrence Journal World say, hey, we're part of this, how come they get copies of that and we don't? So, there are a lot of thorny slippery slopes, someone said, you can get into. I'm not now recalling how the judge resolved that. Maybe the Journal World can enlighten me, but that can be a real issue. I don't have anything else. I just wanted to bring that point of discussion up. As to jurors, and this was done in the Lawrence case I'm just referring to, very good process in my mind. Judge designated ahead of the verdict a room where the jurors who wanted to be, or didn't mind being interviewed, or were amenable to being interviewed, could go to after the verdict and be interviewed, while the others would be, let out of the building without media training. So in this case, I can't remember how many of the 12 agreed after the verdict was rendered to submit to media interviews, but those jurors then were escorted very calmly and cordially to the room where the media were set up to do the interview. I think that's the best of all worlds. Some of the judges will frankly lock down the courtroom until the jurors are whisked away in the bus. So it, again, it's the local legal culture and the mindset of the judge.
Yeah, the judges will, my judges have, always at the end say that tell the jurors that obviously they are entitled to talk to the media, if they're so inclined, and to the prosecutor and defense attorney at the end of if they're so inclined. If they're not, then they don't have to, and if anybody bugs with me, the judges I have always says, if you're getting hassled, come and see me by anybody. I know in the high-profile Taylor case, not one juror wanted to, and they asked the judge to be kind of escorted with security kind of out the door, and so that's I believe how he handled that. I might just jump back to the exhibit, the whole camera issue was kind of jumping back, but certainly that's the biggest. We had several issues in that trial with just like we talked about, some of the courtrooms, and especially in these old courthouses around the state, are just not made for conducive to proper video conferencing. The juror, in Osage County, the juror box was directly, this close, probably one juror sat here and the witness was right here. It almost was impossible for the camera following the rules that you do not take a picture of the juror to somehow, it was, and same thing with the exhibits, and that sort of thing. So it is difficult in a lot of places to ensure that we follow the Supreme Court rule, and that the media does too, without getting a judge calling them back to their chambers to say, how come I saw this on the news last night and it shouldn't be there.
Well, and John, to follow on to that point about exhibits, and this follows on the point that I made about visiting the courtroom ahead of time. Good idea to find out, to look at the sight lines, the angles in the courtroom, so you'll have the best opportunity to see the exhibits when they're put up on the overhead, when they're put up on screens or whatnot. There's nothing more frustrating than trying to cover a trial, listening to the witness testify about an exhibit that you can't see. So do the best you can, and perhaps maybe even talk to the court personnel about maybe changing a little bit of the way they do things to maximize the chance that you have to see all of the evidence while it's being presented. Let's jump now to the appeal process. Most high-profile cases, we've been talking about criminal cases, so obviously a lot of high-profile cases that are civil matters, lawsuits for money damages. But absent a guilty plea in a criminal case, most high-profile cases end up with some kind of an appeal. Ron, why don't you tell us how a journalist can follow the appellate process in a way that allows him or her to report on it?
Right. Well, again, I've already covered the website. That's number one way to do it. Number two is to call me. Number three is to just understand the process. Within, I'll have to correct myself on the exact number. I think it's within 30 days of the journal entry, they're asking those to appeal file. Anyway, it's all set forth by court rule, and if you call me, I can find out where we are in that process. Everything in this building, unless closed by a specific statute, is open. Just know that. Any brief that's filed by a lawyer, unless, as I say, it's maybe a child needing care is referred to by initials only, or things of that nature, you're going to get access to it, and I'll make sure that happens. But the big step in a high-profile appeal would be the filing of the appellant's brief and the defendant's brief. And so far in these capital murder cases, Jackie, they've been about 600 pages. So I've got something I'll be able to photocopy for you, but you're welcome to come and do that. We do not have briefs. We have briefs online. I don't think we do. But in any event, anything that is in what we call the flat file, that is notice of appeal, journal entry of judgment, motions for whatever, motion for transfer, all that material is readily available electronically. Briefs come in, and each side has 30 days to reply to the briefs. All of that is available in the library, the first floor, or for the clerk's office on the third floor. Of course, the cameras are allowed at the oral arguments, and when a decision is filed. By the way, you have my business card. I do a synopsis of case of appeals decisions that are filed or that are sent by email to my media list the same day that appeals are decided by the court. So, as well as a link to the full text of the decision. So I do try to send the results of appeals out so that whatever media is involved, needed or not. I'm not promoting that you cover or write about this appeal, but FYI, here's what the court said.
In fact, Ron told me that there are some cases where, when he told me about the process, it became clear to me that there's some cases where the little blurbs that he writes would be more valuable to you than the actual court opinions. He used as an example the opinions in the school financing cases. I don't think there are 5 lawyers in the entire state of Kansas who could read those opinions and understand them. I certainly couldn't. So I would rely on what Ron, on Ron's summary of those decisions, at least to point you to the right places in the opinions to look for relevant material. I should also point out that on the federal side, that everything, I think this is true, everything is available online on the PACER website. Obviously, beginning with the cases when they're at the trial level, the U.S. District Court for the District of Kansas or the other district courts throughout the country, then up to the U.S. Circuit Courts of Appeals, and then finally, of course, to the Supreme Court. All documents filed in those cases are available online. If you want to download them and copy them, yes, there's a charge, but at least you know that if you want to find out what the content of the appellants or the petitioners or respondents' briefs are, you can get them.
Could I put a footnote? Sure. All records are available except affidavits supporting arrest warrant from the state courts.
Okay. I think that's subject to the open records law, or it's an exception to the open records law.
Well, it's what it states.
Okay. John, do you get involved at all in the appellate process?
No, other than getting all the materials from the local court up to the appellate court on the times that we're supposed to.
Now, the big event, at least from the point of view of journalists, I guess, in an appeal is oral argument. And Ron, why don't you tell us how that works, who's here for the argument, and the possible availability of parties or participants for interviews?
Well, defendants are never here at oral argument. Their attorneys are sometimes. The victim or victims' families will show up. Sometimes the defendant's family or friends will show up. So there are rare, but sometimes photo ops or opinion interviews available that route. So the attorneys come up to this podium, they get 15 minutes aside, first the appellate, and then the appellee, and then there's sometimes rebuttal. Out of that, within a half hour, you're good to go, you're gone. We do require a TV crew to set up before court in the morning, even though the appeal may not be until 10 or 10:30 that morning, you have to have camera in place ahead of time. But, you know, if you've ever watched, you'll know that a appellate court can make the most sensational murder case it always does. So, but it is totally open. I want to make sure we have time for questions.
I just want to add a couple points that we have actually several minutes for questions. On an oral argument, the one thing you won't have to worry about is a witness schedule or when's it going to start, how long is it going to last. The Supreme Court runs the trains on time. If the oral argument is scheduled to start at 10:30, it will start at 10:30. It will be over probably by 11 or a few minutes thereafter. And one final question for Ron, and that is, generally speaking, and I know I don't believe there's any sort of rule on this, how long does the court take from oral argument to actually issuing a decision? And I'm not asking for anything binding here.
That varies so widely. As we heard earlier today, the Court of Appeals will have oral arguments within 60 days, and sometimes, surprisingly, within a week or a week and a half, we'll have a decision that I can, it's filed with the clerk's office that I can release. The Supreme Court, on the other hand, takes months and sometimes longer than a year or more to get a decision out on a case. And a good example is the one that was just filed, the medical malpractice cap decision. I think it's an opinion up here, but it's been argued on two separate occasions, but it was up here for 3 years. But, as you may know, medical malpractice caps is not this snap decision that they made. And courts are different all over the country about that. But so I don't really have a good answer for you. The best thing you can do is keep handling me about it or watching our website on Fridays.
Okay, we've got a question back here.
Well, a statement. I'm Joe Perrin of the Court of Appeals. We
have
have
to-
a lot.
No, we have to be on microphone.
Well,
Sorry.
the Court of Appeals has a lot of oral arguments, and many's the time when a case will settle at the last minute or a day or two before, and that will mess up the schedule. So you can't always be sure that they're going to be exactly the way they are scheduled because of that. So call ahead if you're really concerned about it.
Thank you, Your Honor.